United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can we have the roll call, please?
Chair Miller,
Here.
Commissioner Green,
Here.
Commissioner Bunch,
Good evening.
Commissioner Bartholomew has an excused absence, Commissioner Larson,
Here.
Commissioner Spilsbury,
Here.
Commissioner Cochran,
Here.
Commissioner Bailey, and Commissioner Hill.
Okay, we need to approve the minutes of the February 2nd, 2026 meeting. Do I hear a motion? Approve.
I motion to approve.
Second.
Any questions or discussion? All those in favor, say aye.
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 Opposed? Abstentions? The minutes pay. Approval. Okay, so the hearing board appointment, the hearing board, as I'm familiar with, does not meet very often, but we do have to have planning commission members serve on that board. And right now, I think I'm the only one left. So we need two more board meetings, members to serve on that committee. Any volunteers or nominations for the?
I'd volunteer.
Ted? All righty. We do need an alternate, so who else?
Hill. Commissioner Hill volunteered.
Okay, great, really. Okay, so we have our hearing board. I did recognize you. Thank you. All right. Do we have any comments from the public that's not on the agenda? All righty. Well, we'll go into public hearing. As next on our agenda is a quasi-judicial public hearing regarding planning file SP-15-25, NR-03-25, and RL-08-25. The proposal is for the construction of a 108-unit multi-dwelling development, a natural resource impact review for encroachment into the riparian corridor overlay, and a replat to consolidate 3 lots into 1 unit of land. So the order of tonight's proceeding is the staff report, preliminary questions for staff, testimony from the applicant, questions for the applicant, testimony from individual appellants, questions for the appellants, public testimony in favor, in opposition, and neutral, rebuttal by the applicant, procedural questions for staff, commission deliberations, and a final decision. If you wish to testify, there were 3 options available as described on the agenda. If you've not yet provided your information on the sign-in sheet, please do so now. So I call to order the quasi-judicial public hearing at 5:19 p.m. Do any commissioners wish to declare a conflict of interest? Do any commissioners wish to report an ex parte contact? Do any commissioners wish to report a site visit?
Yes, Madam Chair. I went out there.
So what was yours? What did you observe? Did you just go past, or did you actually walk around?
I went around and I kind of drove around. I've got a gimpy leg, so I didn't walk around out of my car. I just drove around a little bit. Observed several blocks worth of property out there and just took a look.
Oh, great, thank you, Ron. Commissioner Green. Do any commissioner wish to abstain from participating in the proceedings? Does anyone wish to challenge the Planning Commissioner's right to determine this matter or the participation of any commission member in this hearing and decision? If you are attending online, please turn on your camera and raise your hand to be called upon, or if you're attending by phone, please unmute yourself and state your name so you can be called on. I now call for the reading of the meeting procedures.
Good evening. For all those wishing to testify, please direct your testimony toward the applicable criteria of the case or other criteria in the Comprehensive Plan or Albany Development Code which you believe to apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the city or other parties the opportunity to respond to the issue precludes appeals to the City Council. If additional documents or evidence are provided by any party, the Planning Commission may allow a continuance or leave the record open to allow the parties a reasonable opportunity to respond. The failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient detail to allow the local government to respond to the issue precludes an action for damages in circuit court.
Thank you. Will the project planner, Jennifer Zappello, please present the staff report?
Okay, I'm Jennifer Sabella. I'm a planner here with the City of Albany, and I bring to you tonight SP 15-25, RL 0825, and NR 0325. The subject properties consist of 3, which are 1190 53rd Avenue, 1122 53rd Avenue, and 5310 Pacific Boulevard. The site is composed of those 3 properties, and they consist as a total of 8.29 acres. Once consolidated, the subject property would be split zoned with mixed-use commercial and open space. A location map can be found in your agenda packet on page 51. Approximately 4.9 acres of the subject property are located within a natural resource overlay, and those consist of open space, floodplain, significant wetlands, riparian corridor, and hillside. The application package does not propose any development in the open space zoning, the floodplain, and the significant wetlands. The proposal before you is an application package that is for the construction of an apartment complex consisting of 108 dwelling units, a natural resource impact review for encroachments into an amended riparian corridor, and a replat to consolidate the 3 properties into 1 unit of land. The apartment complex will provide 42 2-bedroom units and 66 1-bedroom or studio units, 145 parking spaces, indoor and outdoor common recreational spaces, and a children's play area. The findings addressing the replat are found under the tentative plat review on pages 15 of 20 of the agenda packet. Findings addressing the standards of the proposed development of the apartment complex are under the site plan review and are located on page 20 through 41 of the agenda packet. The application also included that natural resource impact review. And so prior to applying for the development permits, including the site plan review and the replat, the applicant had a wetland delineation completed upon the subject property to locate the upland boundary of the significant wetlands. The site plan submitted with the application materials included the updated location of the significant wetland boundary and its associated riparian corridor boundary. Due to the location of the amended riparian corridor, the applicant has applied for a concurrent natural resource impact review for 3 encroachments into the updated riparian corridor. As a part of the natural resource impact review, the applicant has provided a mitigation area upon the subject property to mitigate and enhance the degraded riparian corridor to marginal quality as defined in the Albany Development Code, Table 6.410-1. Findings addressing the natural resource impact review are located on pages 41 through 50 of the agenda packet. The review criteria for the combined applications can be found in pages 15 through 50 of the agenda packet, as well as in the development code under 2.450 for site plan review, 11.180 for tentative plat review, and 6.310 for natural resource impact review standards. I will note that when the application came in and was vested, it was under the May 23rd, 2025 Albany Development Code and not the current one that's posted online, which is an effective date of November 8th of 2025. During the appeal period, the Community Development Director issued the notice of decision on February 19th of 2026. 2 separate notices of appeals were submitted. The first notice of appeal was received but from Roger Nyquist and Elaine Albridge. I may have said that last name wrong, I'm sorry, on March 3rd, 2026. And the second notice of appeal was received from Bill Bell and Amanda Fee on March 5th of 2026. Pages 7 through 12 contains copies of the submitted notices of appeal with attached defects and interpretation of the criteria associated with this case. Staff has proposed 23 conditions of approval. A list of the proposed conditions can be found on pages 50 through 52 of the agenda packet. There are 3 options for your decision tonight. First being, option 1, affirm the applications as proposed in condition. Option 2, approve with modifications. Option 3, remand the applications back to city staff. Option 4, reverse the applications. Option 3 is chosen, the reviewing body elects to remand the matter back to the previous review body for such further consideration. It must include a statement explaining the error found to have materially affected the outcome of the original decision and the action necessary to rectify such error. If option 4 or 2 are chosen, the reviewing body modifies or reverses the decision of the previous review body. The reviewing body shall set forth its findings and state the reasons for taking the action of denial or modification. And that concludes my staff report.
Thank you, Jennifer. Do any commissioners have any questions for staff? Okay.
Aha, now I turned on my thing. Okay. I have a list of questions. Let me just make sure that I'm at the right part of my list. Okay. My first question is, the traffic study that was done notes that view distances could not be assessed due to construction. Is that to be remedied before approval and/or development begins?
So we have site clearance requirements in Albany Development Code 12.180 that we are using, and there's nothing in the existing public right-of-way that posed as a site clearance issue with the intersection and the right in or right out restrictions. This limits the need for the site clearance for westbound traffic and exiting the site for the eastern entrance.
Okay. Also, 2 nearby intersections are the subject of much public concern. If any reassessment is to occur, would it be unduly burdensome for those intersections, Morse Avenue Southwest and 99 East, and College Park Drive Southwest and 99 East, to be added to the assessment to see if the downstream effects of the development will have deleterious impacts there? It seems like ODOT is or are happy to review the data, so if they're willing to make this further assessment, that would also help.
For that, I will ask upon our Public Works traffic specialist.
Aaron Heemstra, Assistant City Engineer. So this development, based off our code, would have normally only triggered a level 1 traffic study, which is the trip generation and distribution. With the intersection there and the concerns for queuing analysis for impacts to the ODOT right-of-way, the study was scoped just to look at that 99 53rd intersection. So it was not scoped to go beyond that to any of the upstream further intersections. So it did not go through the full ODOT scoping to be able to figure out those impacts.
Okay. And would it be unduly burdensome to do that, or is that part of a normal traffic review just at a higher level? Is that something that's routinely done?
That is usually done when you have it scoped as the full TIA. When they go over 100 trips, they look at upstream intersections.
Okay.
But usually with this area, it's usually up to like the 34th Avenue intersection and then down to the signal to the south.
Okay.
As those major traffic signals and the impacts to those signals.
Yeah. I understand that. I think there is some legitimate concern regarding the housing area to the north that has only one point of egress. I suppose, is there any available data to speak to the downstream effect it would have specifically on them and their emergency access and the availability of egress, and if this would negatively impact that in any way.
Are you referring to 53rd Avenue?
Yes.
So 53rd Avenue was developed with the subdivision to the west. I always want to call it Critter Flats. But so as part of that, there was a local improvement district that was formed as part of that. And then after about 3 or 4 years, the city formed it and upgraded 53rd Avenue. So 53rd Avenue is developed from Willetta West having 20-foot wide travel lanes, which acts as an emergency access, because that's 20 foot is the minimum. But with that 20 foot, it can also be used as two-way traffic in and out. Okay. So the eastbound lane and the westbound lane are both 20 feet wide. It can both act as emergency accesses as needed.
Yeah.
And that was primarily to meet the fire code.
Making sure that I have my facts and maps straight in my head, because there are a lot of intersections and technicalities here. Are we referring to the same thing with regards to there was a concern for an exit from a neighborhood that there's only one exit from due to a cultural finding, due to a cultural resource finding, a native burial ground or something like that? Are we talking about the same thing? Are we talking about that right now?
No.
Okay, so can you speak to that and sort of correct me on where I'm talking about now?
The cultural resources, I do not know where that is.
Okay.
No, you're talking about the same 53rd area. Here, I'll share my screen again.
Okay, thank
pulling
you.
that up.
Thank you.
Sorry. So the subject properties are here. 53rd, from what Mr. Heemstra was saying, is improved from Willetta with 20-foot lanes all the way down 53rd down here.
Okay, okay. And the neighborhood that was mentioned that had only the single point of egress because of a cultural resource finding. Where is that located in this?
That's right here.
Okay.
But there are 2 points, or there are a few points of access to 53rd. All have that enhanced.
Okay, okay, thank you. That answers my question neatly. Now I'm making sure that I have all my other questions. I think that, yeah, that's it for traffic right now. Thank you. Thank you very much. So I wasn't quite sure, and I don't know who can best speak to this, but in reading over the documentation, it was a little unclear to me. Is Mr. Nyquist and Lakeshore Lanes in any way compelled to grant the easement as a condition of the zoning and land use alterations made around his property? Or was that simply assumed as part of the original staff study to have been the case, and then it hasn't necessarily been decided yet?
Are you asking if during previous land use approvals on the Nyquist Ventures properties, if there was a condition of approval to supply an easement?
Yes.
There was, yes.
There was? Okay.
Correct.
So, all right, that answers that.
Any more questions?
What's that?
Do you have more questions?
Yes, I have a few more.
Okay.
I'm sorry. I going over this, I had a lot of questions from people, so I wanted to make sure to get all of my points on the record. What criteria, if any beyond expert opinion, are used to arrive at the determination that infrastructure, sewer, drinking water, et cetera, are adequate to a proposed land use? I ask because there appears to be some question as to capacity. I'd like to be able to address that with something more than, trust me, it's okay.
Yeah, so that would be another question for Mr. Heemstra.
Sorry. Don't mean to be making you do calisthenics there.
It's all right, I could use it.
Okay.
So the infrastructure in this area has plenty of capacity. So our capacity is determined generally when we do our master planning. So we have the sewer, storm, and water master planning. So for instance, water was just recently done as the latest master plan, and it did not show any deficiencies here. Our water system is generally oversized for domestic use. It is sized for fire flows as opposed to just general domestic service use.
Okay.
So there's no fire flow concerns, there's no water quality, and there's no pressure issues.
And so you mentioned a local improvement district. Was that taken into consideration when putting the infrastructure in this area, or was that only for the roads are infrastructure, but was that taken in mind for developing things like water access, power, things like that?
Well, our master plan has the size of all those, and it projects what the development's going to be in certain areas. So the infrastructure here is sized to be able to handle all the infrastructure or all the needs to the west, as well as any undeveloped lands surrounding it.
Okay, good. Thank you. And yes, I do have a few more. I'm sorry. Are there any applicable criteria and/or has a study been done to see if there are any protected or endangered species in the area? One resident comment mentioned beavers, and another mentioned a variety of animals that move through the area. And then one recently received mentioned a species of turtle. I know turtle habitat mitigation was discussed in your report because that was discussed as being specifically within the province of ODFW. But I'm curious if you did anything else if there was any study done to make sure that this wouldn't impact any protected species.
Hi, I'm David Martineau, Planning Manager. And so the question was about the beavers for one thing, and according to Oregon Department of Fish and Wildlife, beavers are not considered a sensitive or endangered species. As for the other wildlife in the vicinity, you'll note that the property is zoned mixed-use commercial on the east side, and it's zoned open space on the west side. And the purpose of the open space district is for the preservation of recreational areas, wildlife habitats, wetlands, natural areas, and flood conveyance, among other things. There's no development being proposed in the open space zone that delineate a significant wetland or the floodplain portions of the property.
Okay, but you haven't necessarily, so that is to say you understand that the open space to the west is for the purpose of protecting, like amongst other purposes, it's for protecting sensitive species and ecosystems. But there has not been a specific study on things that are not open space, like anything that's been specifically impacted or that will be specifically impacted by this site, and as to whether there are any particular species of concern there.
There has been no study done on anything else outside of those areas.
Okay. And similarly, while there's an inadvertent discovery plan, has any effort gone into a survey as to whether there are significant cultural resources present in, especially the riparian areas or the wetland intrusions of the site? From what I gather, there is a significant native site to the north, and I understand that I think it's to the west actually, and I understand that there tends to be artifacts and sites present within the river meanders in the region.
So the approval was granted originally in February 19th of 2026.
Mm-hmm.
So it wasn't approved. I think the second paragraph talked about it being late last year. But the approval was actually granted on February 19th of this year. We're not aware of any archaeological studies undertaken in the vicinity of this proposed development. The notice of this development was sent to the Oregon Heritage State Historic Preservation Office and the Confederated Tribes of the Grand Ronde. And the city's comprehensive plan requires that an inadvertent discovery plan be in place and that the tribe to be contacted if the cultural resources are discovered. We have received no comments from the state nor the tribes, and an easy option for protecting archaeological sites on private land is to avoid them altogether, according to guidance from the State Historic Preservation Office. And that would mean no grading, but placement of fill just keeps them protected.
Okay, absolutely. And have any recent legal changes, I know there was a change in the status of Beaver, you mentioned particularly, and in any new legal changes regarding CRM, Cultural Resource Management. Do any of these affect this in any way, given that the original approval happened in 2025? Or do state law changes that have taken effect beginning in 2026, are they still going to affect?
So the approval was 2026. It was February 19th of
Oh,
26.
that's right, yeah.
And there are some efforts at the state level, at Department of Land and Conservation and Development, looking at enhancing what they call Goal 5, which includes historic and natural resources, but also cultural resources. And as far as I understand, they're in the middle of rulemaking process.
Okay.
And so we would expect some new guidance to come out, probably no sooner than 2027.
Yeah. The rulemaking takes a while. Okay, thank you. And condition 22 mentions the application of an herbicide like Roundup, glyphosate, to remove non-native grasses and forbs. Is there anything incorporated by reference or assumed to be true to follow the normal application guidelines for that spray? I assume FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act, applies here. So for things like rain-free days, warm sunny days, a maximum level of wind, to prevent avoidable runoff into the nearby riparian and wetland habitat.
So typically, natural resource consultants that we see recommend using Roundup or glyphosate. You said it better than I could, the G word there, to remove non-native, thank you, grasses and forbs. They also recommend that that be used for the effective removal of Himalayan blackberries. However, in this instance, in this project, Zion Consulting simply stated that removal may include the use of power tools or through the application of herbicides by a licensed professional. And so if you have some concerns of that, we'd be happy to amend that condition so that it specifies application guidelines in the event that herbicides are used.
Okay, that makes sense. And I mean, a licensed professional using it would likely follow all of those guidelines anyway, considering they're federal guidelines for using it as an herbicide.
One would think, yes.
I would hope. Okay, one comment mentions a conditional approval of the cell tower in the area that required nothing be built within a radius for safety reasons. First, is that an accurate statement that was made? And if it is, has that agreement been considered? What effect does it have, if any, on this development?
Yeah, so there is no condition of approval for that communication tower that required a no building area.
Okay.
It just required landscaping for buffering.
Oh, okay, cool. And I assume that all materials to be used in building or improving the site have to meet standards for toxic or ecologically harmful materials, such as heavy metals, oils, pesticides, etc. One comment mentions a concern from soil runoff from grading materials brought into the site. So, I want to make sure, is everything meant to be up to the safety and environmental standards, and assumed to be that's what it's going to be?
Correct. And Mr. Heemstra can talk a little bit more about this. We do have an MS4, which requires us to do erosion control and sediment protection. But I'll let Aaron talk more about it since he's the expert.
Okay.
So
I can do some more calisthenics.
That's right. So the city of Albany is a MS4, which is a municipal separate storm sewer system.
Okay.
So we're a phase 2 jurisdiction, which means we have runoff requirements for post-construction. So all development of impervious surfaces have to go through detention and treatment before it can be released to our storm system, which also requires that we have to test and monitor all discharges of our system to waters of the state. So in this area, we do have a point that we have to test and monitor just downstream from this development.
Oh, okay.
And then as part of that MS4 permit, we also have the erosion prevention sediment control permit, which limits any contaminants from leaving the site during construction.
Okay.
So
All right, excellent.
so not just sediment, but any contaminants And then also as part of that MS4, we do look at pesticides as well, because our municipal code, I believe it's Title 12, has restrictions on pesticides being used near water bodies and runoff from the pesticides.
Yeah.
So we do have a stormwater technician that inspects all that.
Okay, excellent. And I'm sure there's also a lot of legacy pesticides that get tested for, because, you know, anytime water runs off, there's an amount of old pesticide that winds up, you know, being rinsed off into the water system. Okay.
Yep, and environmental services is the one that really regulates
Yeah.
that.
I just mentioned that because that's a lot of what I test for. So, all right, and finally, one comment from Holly F. or Holly H. mentioned that her home is within the 1,000-foot noticing perimeter, but she never received notice. Was she provided by the developer with a prior notice of development, to your knowledge?
So I looked that up. I looked up, actually provided me with two different Hollies. One was Holly Halligan and another was Holly Flom. And so Holly Halligan's property on Elk Run is located 1,012 feet from the corner of the Schneider property.
Oh.
And so what we do, though, is that we use our GIS system to determine the mailing list for properties that are within either a 300-foot or 1,000-foot radius. And so that's how somebody that's even 12 feet away might not be included in that. But nevertheless, we did receive comments from both Holly Halligan and Holly Flom, and those were made part of the record. And then also both received the notice of decision.
Okay, good. I just wanted to make sure all of that was taken care of. Thank you very much. That's all my questions.
Anybody else have any questions? Covered everyone. Okay, we will now be taking testimony from the applicant. Will the applicant please state your name and address for the record?
Good evening, Chair, Planning Commission. My name is Mike Reeder. I'm at 375 West 4th Avenue, Suite 205 in Eugene. I represent the applicant, and tonight I want to address my comments mostly towards the issues that were raised in the Nyquist appeal. And I've provided you with a hard copy of my written material for this evening's Planning Commission. And I tried to make it as easy as possible to follow along. I am not going to read it verbatim. What I am going to do is I'm going to address some of the pertinent issues that were raised in that appeal and address them as we go along. My client, Schneider Homes, Inc., has been in business for 50 years and provides homes, single-family homes, townhomes, condominiums, and apartments. My client has owned this property since the early 2000s and wishes to develop this property pursuant to the zoning on the property. Specifically, my client owns what are now known as tax lots 606, 1200, and 1300. And the planning director correctly approved the application, and now we have an appeal this evening. So Mr. Nyquist, through his attorney, admits that he has not provided a reciprocal easement to the subject property across the Lakeshore Lanes property. This admission, although potentially problematic for Mr. Nyquist, is irrelevant to the merits of the application, and I'll explain that in detail tonight. Mr. Nyquist is required as part of past land use decisions to provide access across the what we call the village center property. So it goes by a number of different names, but back in 2004, 2005, as part of a broader comprehensive plan zone change application, the city council adopted new zoning for this property and identified the Nyquist property and the Schneider Homes, Inc. property as part of a village center. And at the time, I don't know what the status is now, but at the time, this was the third village center area designated for the city. And as part of that plan amendment zone change, the city adopted specific conditions of approval. The plan amendment zone change included a concurrent application, a site plan review for a bowling center that I will talk about. In August 2004, the city council approved with conditions the site plan, and that site plan is identified as file 1404. And in that August 2004 decision, the notice of decision includes two important conditions of approval. And the first condition of approval that I want to highlight is condition 6.1, second bullet. So the nomenclature is a little odd, but it's condition 6.1, second bullet, and this is what it says. It says, the village center Main Street shall be developed like a public street with sidewalks, crosswalks, landscape strips, and street trees. It is recommended that the design of the village center Main Street comply with the city construction standards for public streets. So there's two provisions of that condition of approval. The first one is mandatory. The second one is a recommendation. And then the next bullet point, condition of approval, is allow for extension of the village center Main Street travel aisles and pedestrian corridors to future development. Submit copies of recorded reciprocal access and parking easements for all properties in the village center to promote efficient circulation between users and properties and to promote connectivity and dispersal of traffic. These conditions of approval were justified by a staff report, and that staff report is pretty thorough. And if you go through that staff report, it shows that the rationale for providing this condition of approval for a Main Street for the village center was really in lieu of requiring the developer to put in a public street. So the city allowed for a private street that was similar to a public street, and it was to allow for the efficient development of the village center, which included the Nyquist property and also the property currently owned by the applicant, my client. And when this staff report came out to justify it, it specifically identified the acreage for the village center. And that acreage it varies between 7.9 something acres to 8.5 or 8.6 something acres, essentially about 8 acres, which includes both the Nyquist property and my client's property. So the subject property was meant to be benefited from the requirement that Mr. Nyquist provide access to the entire 8-acre village center via driveway. And again, that sometimes called a driveway, sometimes it's called a main street, sometimes it's called a private street. Finding 7.2 on page 13 of that site plan review decision from 2004 says the proposed village center Main Street will be developed like a public street with pedestrian access, landscape streets, and street trees. And the revised staff report describes the Main Street Village Center concept on page 14, findings 8.1, conclusion 8.4, and finding 9.2. The city council made a policy decision. The city council decided that in order to approve the plan amendment zone change and the bowling center site plan review, that they were going to require Mr. Nyquist to provide reciprocal access for the efficient development. The bowling center site plan approval relied on the so-called driveway that connects to Highway 99 as being designed and constructed as a village center Main Street in order to meet the criteria for the code, and that criterion is 8.415 buildings along public streets. And that's required as part of the city's commercial design standards. The staff report report makes it clear that the city approved the site plan for the bowling center by substituting a public street for the private drive, designed and constructed as a private village center main street. So what I did was, being new to this project, is I had to go back and I had to look, what did the land use approvals, what did they actually say? What was part of the village center? And it became clear that the approvals for the village center included my client's property. And if you turn to the back of my letter, Exhibit 1, this is the diagram showing what at the time was called the Matty Property Comprehensive Plan and Zone Change application. That was the foundational document for this property. So this property was not correctly zoned for the uses that are currently on the property and are being proposed. But back in 2004, the city council decided to make this comprehensive plan and zone change with the understanding that there would be a mixture of commercial uses, perhaps office uses, as well as residential, medium-density residential uses. So Exhibit 1 is Figure 7 of that comprehensive plan and zone change written narrative. So this was provided to the city council by the applicant, which included my client and Mr. Nyquist and one other property owner. So when the city council made that determination to make these land use changes, they did so with the understanding that there would be shared parking and shared access. And that's what Figure 7 demonstrates. If you look at Exhibit 2, in 2005, March 2005, the city, pursuant to the plan amendment zone change, approved a tentative partition and a property line adjustment. That land use decision, again, this was Mr. Nyquist as the applicant, included 3 separate conditions of approval, which make it clear that access was to be shared and reciprocal between Mr. Nyquist's property and my client's property. And those are conditions of approval 4.1, 2.1, and 3.1. Lastly, the Exhibit 3 shows that Mr. Nyquist understood this because he had his engineering firm back in 2005 show what was then a proposed location of the main street. And I've highlighted in yellow my client's property to the west, tax lot 606. And then also in yellow is the proposed location of this private driveway, the main street. And you'll note that note 4 there, again, this is from Mr. Nyquist's engineering firm. All proposed parcels and the adjacent property to the west, tax lot 606, and that's my client's property, shall share the reciprocal driveway easement to gain access to Highway 99 East. I'm not sure why at this time Mr. Nyquist is suggesting that he is not obligated to provide access to my client's property. I understand that his attorney has provided some plats showing that there are no recorded easements, and he has affirmatively stated through his attorney that he will not provide access. I believe that that would be a violation of his approvals and his conditions of approval, and he cannot collaterally attack his own decisions through this particular land use application. Now, I want to state for the record that it's my understanding that my client doesn't have a practical desire to have access through the main street for these 101 units. We have sufficient access on 53rd Avenue, from 53rd Avenue to Highway 99 East. And our traffic study shows that that is sufficient access. The traffic tech memo provided by Mr. Nyquist, transportation engineer, shows that 53rd Avenue and Highway 99 intersection meets the city's mobility standards. We agree with that assessment. Our traffic engineer has reviewed that and concurs with Mr. Nyquist's traffic engineer. And so, but for the city staff's insistence that we show access through Mr. Nyquist's property, we would rather just have, my client would just rather have the traffic go into 53rd Avenue. So really, it puts my client in a really tough situation. He's either has to show that he can provide access off of 53rd, which he has done, but yet perhaps upset the neighbors to the north, or show secondary access through Mr. Nyquist's property through the reciprocal Main Street and upset Mr. Nyquist. In either case, it's a lose-lose situation for my client. Property owners are not required to be in lose-lose situations. The right to develop your property is a right guaranteed by the Constitution. State statute, the needed housing statute, which is now codified in ORS 197A 400 sub 1, requires that cities adopt and apply only clear and objective standards, conditions, and procedures. Requiring my client to obtain access through property that he does not own and currently does not have a recorded access easement puts him in an untenable situation and an impossible situation. It's just, it's unfair to my client, especially when the mobility standards for Highway 99 and 53rd Avenue are met even without that secondary access. So under the needed housing statute, I assert that my client is not required to show access through Mr. Nyquist's property. Although we believe that my client has the right to use it under the conditions of approval, land use approval, that's not a preferred outcome. But in any case, the needed housing statute also has another provision that says that the local government cannot apply conditions, standards, procedures, and criteria that in and of themselves or combined unreasonably increase the cost or delay for the, and discourages needed housing through unreasonable cost and delay. And by if the city insists on having my client go through Mr. Nyquist's property, I see a multitude of problems with that could delay, even if this application is, even if the planning director's decision is affirmed, which it should be, I see potential delay as we move forward. And I see that delay as serving no good purpose. So at this time, I would ask that the Planning Commission approve the application, affirm the planning director, and do two things. Make findings that the applicant has met the criteria of approval, showing that there are conditions of approval in land use decisions passed that allow for secondary access should it be necessary, but also making a finding that secondary access through the Nyquist property is not required because there is sufficient access on 53rd Avenue. And that would, I think, alleviate the lose-lose situation that my client's in. And I believe that he meets the criteria for approval regardless. But even if he didn't, even if the criteria for approval wasn't met, the state needed housing statute relieves my client from the obligation of showing that traffic impacts have been addressed. And that is because the property has already been comprehensively planned and zoned for this type of use. Transportation facilities of this sort are the responsibility of the local government. So when local governments plan and zone for properties, they also plan for transportation facilities. And in this case, it sounds like, based on the testimony of your staff, that fire and other access issues have been addressed through what I'd call the oversizing of 53rd Avenue. So with that, I'd like to close my testimony in chief and answer any questions that you might have, and then also reserve time for applicant rebuttal.
Great, thank you. Okay, do the commissioners, any commissioner have a question for the applicant?
Question. Is there a diagram or a map overlay on which the boundaries of the village center appear? Is that anything in the material that you gave us?
Yes,
Does that appear?
Commissioner Green, that's an excellent question. The historic land use diagrams are not as colorful or as specific as I would hope that they would be. But to answer your question, the comprehensive plan approval shows a diagram, and let me find it for you. I believe it's in the record. Jennifer might know specifically. There was a site plan that went with it.
We have a picture of the map up on the screen showing the zoning as mixed-use commercial with a secondary climate-friendly area overlay.
Okay.
And wherever there's a mixed-use commercial zone, it's a village center zone. And so comprehensive plan calls it village center, the development code zoning calls it mixed-use commercial in this case.
So the village center, I mean, I'm sorry to be so obtuse here, but the village center shows up on this map on the east side of 99. But we're talking about the west side, obviously, where the parcel in question is. And the yellow one on this partition plat here, the PA 16-04, is the one in yellow. That is represented as a main street or a potential main street for the village center, is that right? But on the west side of 99, correct? And here the village center shows up on the east side of 99.
It's just the words end up on the east side, but the coloring is the same. So it's just the way it's labeled.
The whole area, so in other words,
everything-
99 runs through the village center.
Correct, yes.
Okay.
But to specifically answer your question, Commissioner Green, the 2004 comprehensive plan zone change application was called Maddie's property. It included the property on the west side of Highway 99 and on the south side of 53rd, except for a tax lot to the very north that's shown in red, north of 53rd Avenue, right there.
Into the South Pacific property.
Yeah, and so the Maddie's property plan amendment zone change for which this whole concept was developed, requiring reciprocal access. Basically, it envisioned looping a road, either a public or private road from Highway 99 up to the north to connect onto 53rd Avenue. And the entire Maddie's property plan amendment zone change was 14.41 acres. That included the property to the north of 53rd and includes the open space and some others. When you back out, there's a table of property ownership and acreage by owner for that plan amendment zone change. And when you back it up, the property owned by Mr. Nyquist and the property owned by my client comes out to approximately 8 acres, which is what the village center is called for all of those land use approvals since 2004.
Okay, thank you.
So it's not as clear as I would like, but it is what we have.
Yeah.
I can provide a little bit more guidance. The village center on the east side was done through our climate-friendly areas, so that was only adopted as village center comprehensive plan about 2 years ago. Yeah, before that was regional commercial.
Any more questions? All righty, thank you.
Thank you.
So we will now be taking testimony from the appellates. First, from joint appellants Roger Nyquist and Elaine Albridge.
Chair Miller, Commissioners, it's not my turn, but I do feel it necessary to attempt to from my view, correct the record on the easement. What happened in 2004, 2005, I don't even know the year at this time. It was a long time ago.
Can we get your name and address?
Oh, I'm
for the
sorry,
record?
please. My name is Roger Nyquist, 2896 Furwood Place in Albany, Oregon. One of the land use conditions were that the parties enter into a reciprocal agreement. It takes two parties. It wasn't that I grant an easement, nor did it pin down where the easement was. And my position has been, and it is today, that I'm happy to enter into reciprocal easement negotiations with the Schneider party. I've talked with Zach Schneider a few times about it. That's made no progress at this point, in part because of his application and the issues before us in that regard. So with that, I'll step back and we have a presentation for you. Thank you.
To share screen. Good evening. For the record, my name is Elaine Albridge. I am outside counsel for Roger Nyquist and Nyquist Ventures and Lakeshore Lanes. My address is with Davis Wright Tremaine, Portland office, 560 Southwest 10th Avenue, Suite 760, Portland 97201. Thank you very much for having us here tonight. This hearing came up pretty quick, less than 2 weeks after the appeal deadline. So we are appreciative of the opportunity to present our case here before you, but anticipate likely requesting some additional time, given that this is a very robust record before you, and there is potentially some additional briefing that may be helpful depending on the direction and the questions that the Planning Commission has of us tonight. That I'll move forward. Tonight's presentation, we'd like to do introductions, talk about the framing of our appeal issues, share with you some history and context around Lakeshore Lanes development that I think will shed some light on the questions that were being talked about, the prior decisions. Offer our evaluation of impacts to Nyquist property and Lakeshore Lanes if the planning or director decision was left to stand without modification. And then discuss our requests of the Planning Commission, provide our legal justifications for the request, and then answer any questions and hopefully try to find a workable path forward. So with that, you heard from Roger the introduction, and then with us tonight, Bill, you want to give your name and address for the record?
Yeah, Bill Riles, architect. I live in Albany at 935 Jones Avenue Northwest, and I've sat for quite a few years in your very chairs. So I understand what you're going through. You want me to go ahead and start?
No, I'm
Okay.
So what we handed out to you was our pre-hearing submittal letter that we had provided to staff ahead of the hearing. I don't think it was in your hearing packet, but I anticipate it was forwarded to you, so that is a paper copy for your reference so you can follow along. Also included in that packet was a copy of DKS's traffic memo that we entered into the record, as well as a copy of our PowerPoint deck from tonight for ease of reference. On this slide, you'll see the location of Lakeshore Lanes as it exists today in relation to 53rd Avenue and Highway 99. It's X marks the spot. That's what we're access point that we are talking about tonight. That's the subject of this appeal. And so this photo, I think, is helpful to see the orientation of the development on the property. The property is comprised of 5 parcels that you'll hear more about, and that the development is oriented such that there is parking areas, pedestrian connectivity between the different uses on the property, between the bowling alley building to the north, and then you'll see the mini golf area to the south. So that whole site is developed as Lakeshore Lanes family activity center with pedestrian connectivity and circulation throughout the property. As we presented in our written submittal, we're here tonight to appeal the director decision because it approves applicant routing 30% of anticipated apartment traffic through the Nyquist property in the Lakeshore Lanes parking lot that we were just looking at. That amounts to about 230 of the 768 daily trips. Our argument is twofold. First, the director decision is not based on substantial evidence to support the findings related to connectivity, traffic, and transportation safety. We provide our analysis of that in the pre-hearing findings, and I'll talk a little bit more about it after Roger and Bill provide some context for this, this appeal. Second, the director decision fails to evaluate and address adverse impacts to Lakeshore operations, even if the access was going to go through there. It is silent and fails to consider some pretty serious safety considerations that we believe we have introduced into the record for your consideration. There is a long history of development here for this property. We have a position that this property has been operating for over 20 years. There is a series of land use decisions that involve the property configuration and the development on site. The conditions, the nature of the decisions, I want to point out, and this is quite nuanced, so I would appreciate an opportunity for additional time to brief these matters, if that's what the Planning Commission would ask us to do, is that those decisions contain findings, conclusions, and then conditions. And so there is language in the findings and conclusions that discuss the village center design, access, connectivity, and then there's those plain language conditions that are in the decisions that require that applicant carry out certain actions prior to the city approving the final plat or prior to the city approving the final site plan, prior to the city issuing building permits, and prior to the city issuing certificates of occupancy. As we'll talk more about, the city has reviewed and approved and issued all of those actions. And so the plat that you have in the record before you shows that there are reciprocal easements that serve the Nyquist property, the 5 parcels that were created through the partition, but there's no reciprocal access serving or benefiting the applicant's property. And that hasn't been required to date. And so we see that there's a series of facts and circumstances here that lead us to argue that a better solution is available to the city for moving this application forward. And with that, I will hand it over to Bill.
What a nice day we had today, wasn't it beautiful? So I have the one advantage in this room, well, there's actually Roger, is that I designed this building, I designed the site plan, and I was there for the whole time, and I remember who the planners were, and I remembered all the discussions are, and there's a lot of things missing. So I'll try to, I think I can make it, architects aren't lawyers, so I think I can make it pretty down to earth for everyone. There are several reasons why this current iteration of this development is lacking and not taking into consideration all the issues that are there. But first I'm going to start with a little history. So, Village Center. I was in the middle of that. I was tasked by our previous mayor to be in on that, and we had this livable city idea. The problem is we ended up building the hotel while that was still being worked out. And so the code wasn't completely settled till we were sort of settled with our building. And one of the reasons all the things aren't in place is that they weren't even legally in place by the city while we were building. But we had a lot of discussions, and one of the discussions was this interconnectivity, and it's a good idea. But the thing that's striking is that we never looked at interconnectivity over on the creek. That's the back of the building. It's not a center road. Our entire idea for interconnectivity is through the middle of the development or the front end of the development. Commissioner Hill brought up a great idea, several great I appreciate your questions. We took very seriously the impact along Oak Creek and the wildlife and potential archaeological finds and those kind of things. And we sited the building in a way that it would have the least possible impact and come fairly up close to that. And it was never envisioned that there'd be some street that would be trying to skirt its way along the edge of Oak Creek. It's very expensive, but we were also concerned that how do you do a cross-party easement when you don't even know what the other party is? What we're not handling here is the basis of all planning. It goes back to a man named Vitruvius at 200 AD, and he outlined in simple form, you have production areas, you have city centers, you have residential areas, and we look at it as, we have commercial areas, we have public areas, we have residential areas, we have industrial areas, and they have to be in their own area, and they produce conflicts between them. And this village center was unique in all of the code in that it allowed for a use like the bowling alley, a large gathering that might have outdoor dining, it might be a little noisy, it might be a little distracting to the overall neighborhood. And if you look at the way the creek comes by and the way the roads go by, it creates this little peninsula. And it looked like a safe place to put something like the bowling alley. But, it was all aspirations, and we did our best to fulfill all those things. And what we said at the time, it's a great idea if you'll actually, what the attorneys for the applicant shows there, it's nothing like and that's funny, we haven't seen a single drawing of what the actual proposal is. Staff didn't show it. And if you look at staff's drawing of their proposal, the bowling alley isn't even there. What they're proposing is that a road go within 4 feet of the corner of the bowling alley through our emergency access. We're a type 1 facility similar to a hospital and a school because we can fit over 300 people. We have to have a designated area for emergency vehicles. It needs to be a quiet area where an ambulance can park. The city has decided to channel the traffic right through there. I wonder if they talked to their own fire department about it. And it wasn't anything that was ever really envisioned. However, if the city is determined to send traffic out along the creek, we do own enough, the client owns enough room away from the putt-putt golf, away from kids walking across the parking lot with their families and old people coming and going from bowling. The point is, a large apartment development and a large entertainment center have some potential conflicts. They are not noted, they are not addressed. It's unusual. I've done dozens of these kinds of things. I've worked on the Portland airport. I spent about half my career in Portland and San Francisco and half my career in Albany. I do a lot of large developments, and from the get-go, if I'm dumping something like this into the middle of an existing neighborhood, I go out to the neighbors. I have neighborhood meetings. You don't try to slip this in under the rug and end up here in what is essentially, it's not a waste of our time, but it could have been avoided had the city and the developer reached out to Alan and me, and we could have come up with a lot of potential solutions. As it is, there's no recognition of the potential impacts between the bowling center. I mean, their parking lot is 1 foot off of our back property line where kids play ultimate frisbee and where we have dining. There's no recognition that we're even there. So I don't know where to begin. I mean, I'm just going to relax here because, Roger, you take over.
Thank you, Bill. Chair Miller, Planning Commission members, I want to thank you for your service. I know how difficult this can be, and the decisions you're making tonight or at any meeting will affect how this community looks in the next 50 years. I know you know that, and you take this seriously. I also want to thank Zach Schneider of Schneider Homes. He's been accessible. We've had many conversations. And I do want to thank Matthew Reckers and David Martino with the city. We've had a continued dialogue as well. Unfortunately, those conversations have not resulted in any progress in getting to what is an acceptable outcome for us, but I do acknowledge and appreciate the effort. In the way of background, my parents bought a bowling center in 1965. It is now where the Lava Car Wash building is, close to Costco there. They operated it for 15 years. We sold it in 1980 when my mom died. I reacquired the center in 1985, and we never owned our own property. So in 2005, it was a big deal for our family to get our own portion of property and meet up with Bill and build a bowling center. We've operated it ever since. Today, we host thousands of people playing miniature golf every year. 35% of those are under the age of 12, we think. And they go back and forth across from the bowling center to the miniature golf with a multiple use facility. The attraction is the synergy of doing all of those things. That's why, in large part, that area has become so important to us that the proposal is to put not only apartment traffic, but through traffic from 53rd potentially in. And we just think it's dangerous. You got the traffic report that indicated that as well. And what I am not willing to do, and maybe that came to the inference that I'm not willing to do anything, is not right. What I'm not willing to do is put our customers at risk, especially kids, seniors, disabled folks who use those areas. We hosted more than 1,000 birthday parties last year. Most of those, again, were kids under 12. We run a Kids Bowl free program in the summertime, and it averages around 100 kids per summer. 90% of those are under the age of 16. We donate thousands of games of bowling to high school bowling teams. High school bowling teams bring high school drivers, not necessarily so experienced, eager to get in the bowling center. And so, for them, there's no need to generate more traffic. We host weekly summer Special Olympics events for 8 weeks in the fall. We host around 20 field trips, school trips in May and June, and it's high energy with a lot of kids and it's noisy. We host multiple weekly senior care home events on weekdays. Most of them show up in small buses, and I've brought a few pictures for you to see. And so we don't want to put that in jeopardy. They use between the bowling center and the mini golf to load and unload in their buses. Over the last 20 years at this location, Lakeshore Lanes has become a community gathering place. We have had more than 100,000 people visit the facility in the last year. We employ about 20 people. We have made about $40,000 this year in contributions to youth activity programs in Albany due to the support we've gotten from the community. The City of Albany recently completed a $20 million Front Street project that includes Monteith Park as the focus. They did that because having places for community to gather and interact is important. We at Lakeshore have accomplished that through private investment, hard work, and community support. We see no reason to jeopardize everything we're doing to route traffic through an area I haven't agreed to do and won't, when there are other alternatives available. So you got a little booklet. You got these. We'll just go through them one at a time, and I can just show you what they are. The front picture is a picture of the mini golf course. Some days it looks great, and other days it looks like a lot of work. In the next couple of weeks, those crabapple trees are going to be blooming, and it's going to look great. So the first set of pictures are from 10 days ago on a Saturday about noon. I stopped by for about 5 minutes just with my phone and took a few shots. And And during that 5 minutes, there was not a time where kids weren't, or people were not present in that area that would be proposed to be a through street for the apartments and people off of 53rd. You can see a photo there of how popular the miniature golf was that day at that time. And so the next set of photos is the band from the Oregon Veterans Home. They come over from Lebanon a couple times a week. Our place is very flat, very wheelchair and disabled available. People like it. And so you can see I think it's probably the second photo, how far that bus sticks out. And that in itself likely precludes the access area that the applicant's proposal would have you do. And then there's another photo that's got multiple large vans out there. That was just last Thursday. I stopped by on my way over to Corvallis, and there they were, and I took that photo. There's a photo there you can see of those were the members from the Vets Home and bowling. You can see the openness and the flatness and the accessibility to them. And then next, there's the email I wrote to Mr. Martino when I found out just before Christmas that this proposal was out there. And in the second paragraph, the last line, what I said, I want to say it again. Routing outside traffic through that area of the parking lot creates an unthinkable risk. It is an unacceptable risk. And, you know, just about, I run into people in town, people have heard of this proposal, and I haven't found a person yet who thought this was a good idea to run pass-through traffic between a bowling center and a miniature golf course. What really I've not gotten is any other solution other than the one that I'm asking for, and that is that through traffic not go through that area. So then the next photo, this picture of a couple, well, they weren't old, but it's an old photo. It's my mom and dad in 1970. My mom's smiling because she knows my dad doesn't know how much she spent on that Christmas tree behind them. And so I have, I guess, the fortune or misfortune of growing up both in a bowling center that didn't have apartments, and then a bowling center that had apartments around them. And that would be this photo right here, if you can see it. It's an old aerial GIS, so it's not real clear, but what you will see is...
Stick it somewhere.
Hello? I'm just going to keep going if that's okay. Okay, that there's the apartments that, if you're looking at the photo to the left, are next to a lake there. They came there in 1971 or 1969. Prior to those apartments, you could see the lake from the inside the bowling center. That's Lakeshore Lanes. And so they built the apartments. The apartments were 180 feet away. We never had a problem. There was never a conflict. In fact, the apartment manager wound up working a couple days for a week for us. Her name was Dorothy Ross. She was fantastic. I think she's still alive out in Beavercon, or God bless her. And then in 1971, they put apartments behind the bowling center, and they were 45 feet away. And there were conflicts. Being behind a bowling center is noisy. You get a busy bowling center of this size, and you will have a bowling ball hit pins 10,000 times a day. 16-pound ball, 3-pound pins made of wood, noise happens. And so we worked through that stuff, but it was a bit of a challenge for us, and it was also a bit of a challenge for some people who moved in those apartments, in that they would get first and last and cleaning deposit, which was a lot of money. It's still a lot of money. It's more money today. But they would be there and be there a couple weeks and figure out that they couldn't sleep till 11 o'clock or something like that, and their normal bedtime was 9. and they were disappointed. We empathized with them, but we're in a bowling alley, and so they wound up, a lot of times moving earlier than they otherwise would have. And this project before you, I don't know how close the apartments are to the bowling center. It is, it's we're a long ways down the road, and our building is concrete. This other building we operated was it was a metal building, so we gained some advantage there. We have the newest bowling pin setters where the pins are on a string, so there's not as many pins, and they don't clatter around as much between times. So as bowling centers go, our bowling center operation is quiet. What's not so quiet a lot of times are our customers. They come, they have fun, and people having fun makes noise. And so I am concerned over the next 40 or 50 years how a bowling center and apartments that close without any forethought for sound mitigation make it all work. And what happens is people early on call in a noise complaint to the police come in, and now the police officer is attempting to make everybody happy, or at least settle down and stuff. And that takes time away from law enforcement, which is not good. And there are three specific areas around noise that concern me. One is our miniature golf course. Kids in particular, they get a hole in one, man, it's like they just won the Masters. And they're gonna make noise. But that noise is generally in the daytime, and it's intermittent. And we've had a few complaints to the south of us at times, but we worked through that. I bought the neighboring property to us and planted cedar trees in hopes of mitigating it from our neighbors to the south. But you get to like this last thing with the black, it's the last one on there. That is a flow chart of our bowling activity for Saturday 10 days ago. And you can see it's kind of busy during the day, and then it slows down a little bit. But on this block from 10 a.m. to 1:30 a.m., we're full. We're full with Cosmic Bowling, and it's kids, and there's music going. And since this application's come in, I've gone out and walked around to see if will be impacts. And it surprisingly, it feels like it may be achievable, where we can do that without disrupting them much or at all with and in the bowling center. But again, kids are showing up, adults are showing up 10:30, 11 o'clock, and they're leaving at 1:30 in the morning. And they're in the parking lot, they're making noise, and I want to be a good neighbor. I want this to work for everybody for a long time. I'm proud and I'm biased, but I would say as bowling centers go, we overachieve in Albany. You have to go to Roseburg to find something similar to us, or up to Sherwood and East. You can go to Bend and find something, but we've done a good job. We've become a community gathering place, and we want this to work. And so the two issues that are lacking in the way of mitigation in this application, the approval, are traffic and noise. And I think that there's ways to mitigate both, and I just don't think this application and this proposal fully represents the best that we can do. Thank you.
Okay, I've calmed down. I want to mention one more thing. We proposed, many of you may remember this, in 2012 or 13, that we put in a go-kart track there. And we went through a conditional use, and we worked very closely. I mean, it was within.
We proposed it. We didn't put it in.
Right, we didn't put it in. We proposed, we put in an application, and it never got built. But we went through the entire process. We worked with the neighbors. We designed sound barriers and buffers to keep the sound from going clear to the far neighborhood. And so it can be done. And we understood, even though it fell within the preview of our zoning, that we couldn't just do it without working with the neighbors, without identifying possible concerns like sound and proposing some sort of remedial action that could help that. And so that's really what we're asking for here is, maybe it's item 3 where we remand it back to staff to, look at all the issues.
I think now you're taking my slide.
All right.
Okay. With that, though, we do want to wrap this up. Thank you for your time tonight. We are here tonight to request that the Planning Commission overturn the director decision and deny the application for lack of substantial evidence in the record. That is our position, but we think that there are pathways forward. And so I was really glad to see that applicant had retained counsel that was here tonight. We have been asking applicant if they had legal counsel on board in order to talk with them to try to work towards a solution here. So glad to see that Mike was on board, and also happy to hear about the openness to consider other revised findings and conditions to resolve the concerns that we presented in our appeal. There's evidence in the record in the applicant's traffic memo and report, as well as the DKS traffic memo that Nyquist submitted, that it is possible to route traffic through 53rd. We would prefer that routing. We are not opposed to the apartment development as it is. We just want to make sure that it is compatible with surrounding uses and can be developed in a safe way, and that it actually can be developed, because right now, as approved, we believe that it won't actually allow applicant to go to construction, and I think we all want a successful project. So things for Planning Commission's consideration in our position is that staff needlessly applied the connectivity requirements. The record reflects that staff was viewing these as mandatory requirements when the plain language of the code gives the leeway to the city to waive them or impose them, but there is some discretion there. And so our position is that this application could be reviewed in a way where those connectivity requirements are not required because it is impractical or inappropriate due to the nature of the adjacent uses. So we think there's a way to navigate that such that we could avoid the second routing through Lakeshore Lane's driveway and still get to a yes for the apartment development. That said, right now, we think that the director decision approves a design that's not achievable and presents safety risks with the shared access. So we would respectfully request denial. But in the alternative, if it's to the Planning Commission's liking, we could offer an alternative of remanding to staff for further proceedings to address the issues that have been raised on appeal. And hopefully that would provide some additional time, if the applicant would be willing to extend the clock to a date certain, to be able to work towards a revised decision with findings and conditions that work for the neighborhood and the applicant. So with that, we will close and offer opportunity to ask if you have any questions, and then if we are able, save a little time for conclusions at the end.
Thank you. Any questions?
So I'm going to ask staff as well on why that requirement is there through your property. If I thought it did. Can you guys hear me? Okay. My question is, if that is a requirement that has to go through your property, would you be opposed to something on the north end of lot 1400 or even 1401 and 1402, as opposed to driving in between the bowling alley and the mini golf?
So I would need to.
I'm sorry. Can I interrupt?
I'm open to having conversations with the applicant and with the city about what will serve the best interest long-term for my bowling center safety and the community.
Okay, thank you. And I guess, do I have to only, my question is to staff then. It sounds like the applicant and the owner of the bowling center both don't want, it to go through there. Why are we requiring that?
So the requirement is part of the code, and it does have options to be waived. In addition to the Article 9, there's also Article 14, which is the climate-friendly area that requires connectivity. And then it was previous conditions of approval from their comprehensive plan amendment to get that zoning and to get that comprehensive plan and designation of village center. So it's from 2004, but also it's reinforced throughout the code.
But we can waive it?
In Article 9, there is an option to waive. In Article 14, I do not believe there is. And then it would need to fulfill the existing requirements of the conditions of approval from their previous land use reviews.
Thank you.
Question?
So it sounds, so we've got two different things that they're going against each other that make it untenable no matter what, correct? So unless they put the street through, the project cannot go forward according to city code.
We approved it as approved without that easement currently, correct?
Okay. Sounds like something needs to be cleaned up there. That's so okay.
I'm sorry, I didn't mean that. I have a follow-up question. And do the provisions of the code or the conditions of use of the past decisions, do any of them specify that the access road has to be precisely there? Or do they specify that an access road merely must be applied for those, sorry about that. Or do they say merely that an access road of some sort must be supplied in order to fulfill the connectivity requirements?
So as approved in the attachment from the applicant's attorney, it shows where that connectivity is supposed to be. So it's a circular connectivity connecting to the 99 connection through Lakeshore Lanes property as well as through 53rd. And it's not just easement supposed to be through Nyquist property, it's also going through Schneider. So as a condition of approval, they have would be required to do a reciprocal access easement benefiting the bowling alley through the Schneider's development.
Okay. And is there a provision to amend that specific plan with everyone's agreement so that the easement and the road can be routed through a different place?
Correct, yeah. So to do that, the applicant would either need to withdraw their application, reapply, because it would be an alteration to the circulation. And then Lakeshore Lanes would also need to do a modified approval for their site plan review from 2004, because it would also be a modified modification of circulation to their site as well.
Okay. Then, Mr. Nyquist, given what you've heard now, is that a tenable path forward for you, provided the parties who are not here who can't speak, that being the applicant, are willing to go forward with it as well?
So,
like, are you okay with the idea of doing all of the of going through the bureaucratic process to get that road moved somewhere else?
well, I'm willing to go through the bureaucratic process for sure.
Okay.
This business, this property, this building means a lot to me. I think that, I don't think that there's how do I say this? I just don't think there's a road required in a specific place to go through there. Go ahead,
If I may,
counsel.
The 2004 comp plan zone map amendment with the village center concept is incredibly outdated. what was presented at that time is not anywhere close to what's being proposed or has been developed over time. And I think there's a question of whether what was proposed from a design standpoint is even still valid. With respect to that, in today's world, there could be better design done with current data and traffic data and connectivity and reconsideration. So I think the idea of doing a modified village center amendment to clean this up would be a great path forward. I think that there are just issues around the connectivity requirements, whether it be in Article 9 or Article 14, that require the consideration of safety of existing uses and adjacent uses for a proposed development, that cannot override the policy, the planning policy for connectivity.
So it sounds to me, and correct me if I'm wrong, like what is possibly needed here in multiple ways is space and time for you to talk to them, for them to talk to you, for you to talk with the development department, in order to amend and find a tenable way for all of you to move forward with this.
I think you're exactly right. And the other thing I'll say is the approach of Village Center is it was a village center. It was, think Periwinkle Plaza with a bowling center next to it. Now you, by their nature, have two conflicting uses. It's not
multiple use.
It's not a village. If you have a village of a bowling center and 108 apartments, you have mad people. And so what we should be attempting to do is isolate the potential conflicts from each other, and that runs counter to a lot of the village center concepts we had more than 20 years ago.
One more question.
Yeah, just real quick. I'm kind of hung up on the whole idea, the whole situation that we've got two rules in the city code that are in direct conflict with each other. Like, as far as the requiring, like you could waive the requirement, but then you also have the code, never mind.
It's because all of the zones, so Article 9 applies to all parking and connectivity, whereas when you have a more restrictive, such as development in a climate friendly, the climate friendly being the more restrictive would apply.
Okay,
So it's.
that's where, thank you.
Yes.
Question?
Go ahead, Ron.
Following on the idea of amending the village center, is the village center does not go up to the South Pacific property, is that correct? Goes up to it, but does not include it. Is that right?
Correct, yes.
Okay, so in kind of backing up and taking a larger view, is it possible to consider the now recently completely vacant property at the South Pacific site without a street running behind it and up to 49th Avenue, which is a connection to 99, and then to be able to reestablish circulation through that area and include that. Let me just say, Madam Chair, just if you'll indulge me just for a moment, I read those, almost all of those, however many emails there were, 100 and something, almost 200 pages of emails regarding this project. As far as I could see, all of them in opposition to it. And almost all of those based on traffic. So what we've got is two completely isolated developments with people who probably wanted to live in a place, well, they definitely wanted to live in a place that they could only get to by their car, with mostly single occupancy trips. That's what we're looking at. We're looking at single occupancy trips when we're looking at these traffic projections. The climate-friendly idea is an aspirational one to try to build a world in which we don't have to rely on single occupancy car trips to get everywhere. If that South Pacific property had, instead of four-wheelers and cars and motorcycles or whatever they all had out there, if it had a grocery store and a barber shop and things that people need, they wouldn't have to get in their car drive on 53rd and then drive all the way up into Albany to get the things that they need. They could get on their bicycle and go over there, or they could walk or whatever. It seems to me that the development, the overall development, and I know we've gone way out of the, the thing we're supposed to be talking about right now, but looking at long term, and it seems like maybe both parties might be willing to take a step back and consider the long term on this, although I know the builder probably wants to go right now. A different look at this to supersede that 20-year-old idea of the village center could be in order. I don't know if there's anything that we as a commission could do to push us in that direction, but I just want to kind of get that out there. Thank you.
Thank you. Thank you.
I have one more for staff. You'd mentioned the two conflicting rules. Which one is more restrictive that like one we could waive and one we couldn't?
So in Article 9, it says the director may, under certain circumstances, and then connectivity is also required in Article 8 and Article 14.
And those are the climate-friendly ones?
Article 14 is climate friendly, Article 8 is the village center comprehensive plan designation.
So to be more climate-friendly, we need more roads?
You need more circulation. So that connectivity of pedestrian, bicycle, and vehicular connectivity is that you're creating a little village.
Great, thank you. And I would just want to remind folks online that you will have an opportunity to speak later as we get through the process, so please do not unmute yourself if that's okay, please. Thank you. All right.
I want to thank you all again so much. Appreciate your time.
Thank you.
Thank you for your time.
Okay, thank you. Okay, we will now hear from Bill, Giselle, and Amanda Fee.
Madam Chair, I had another question for Mr. Nyquist before he left.
Well, let's hear from them.
Okay, that's fine.
More questions at the end.
Hello. My name is Amanda Fee. I'm at 1641 Elk Circle here in Albany. Bill is, I think, connected online, but he wasn't able to be here. He already had something pre-planned. So thank you very much. I have never done this before, so please bear with me. I'm gonna make mistakes or say things. I wanted to say, I've lived in the neighborhood for 17 years. My husband and I have been there. We've raised 4 kids. And we have visited Lakeshore Lanes, probably hundreds of times. I don't know how many birthday parties. Roger has been an excellent member of our community. And I would like to say that my kids really voted hard for that go-kart. They really wanted it. So they were very disappointed. But I think we've reviewed the plan. We've gone through it. We've looked at the map endlessly with Mike, zooming in on it and looking at how many cars. I think safety, traffic, you're gonna hear it over and over. It's our biggest concern. It really is. I have been on the board for the Oak Creek Meadows HOA for about 12 years. And so I've dealt with a lot of issues in regards to dealing with code. I've spoken with many people within the city. Ron Irish was somebody who actually walked me through kind of what happened with 53rd. The main thing was, obviously, the neighborhood was originally supposed to punch through Moose Run. And during development, that's when they discovered the cultural site. And of course, construction stopped. And that's when they had to start really looking at, okay, how are we going to handle this? It was supposed to punch through. We've built over 600 homes back here. We've got people with multiple cars. And of course, that's increased over time. And I'll come back to that moment. But, they looked at how they could make it more safe. And that was really the biggest concern. So that's when they said, okay, well, we'll look at this plan, we'll expand it. Now we can have 2 sets of cars going out. Basically, if there was really an emergency, you could have 4 lanes of traffic going out, right? But Ron was quite clear. He said in the beginning, he's like, this was not the ideal plan. This is not something we wanted to do. It's not something we ever want to do again. There just isn't enough space to really make it what it needs to be. And I think one of my biggest things when I was looking at the plan, and of course, I saw where they said 1/3 of traffic would exit through Lakeshore Lanes. But I think more that you've got 2 entrance exits on 53rd, okay? But that means you're gonna have people turning left to go in there. So you've got people turning on to 53rd, wanting to make a left into the apartment building. You've got one lane in normal conditions going in, and you've got one lane going out. The majority of traffic is going to be traveling into town. We all moved out there knowing we were nowhere near services. We were nowhere near anything. You've got to take, your car, your kids most kids don't ride their bikes to school. You've got parents. So if you ever sit out at that light right before Liberty Western Memorial start, there's going to be parents, because those buses are not reliable anymore. They don't have enough bus drivers. So you've already got a lane backed up of parents trying to get their kids to school on time. You've got the same backup in the afternoon when they're going back out to pick up their kids back from school, because it is not reliable. They just don't have enough drivers. We understand that. It's just something we've accepted, and it is part of living there. I did it myself. At one point, I had 4 kids in 4 different schools. So I was in and out all day. So I've seen it. And I think they're making an assumption. If you look at just the number of cars, they were making an assumption in there that maybe, 30 to 40% of people would have a car. And I think if you were in an urban area, that would be logical, because there would be walking. And we do have a city bus. Yes, I couldn't find any stats online for how it's used, Route D that comes out by our place. But I do know that it would take you about 30 to 40 minutes on the bus to get to Walmart, which is something most people don't want to do. So you're going to be looking at people moving there, people with the plan to drive. Well, when you have 66 units that have 2 bedrooms, and you've only allotted 147 parking spaces, 145, excuse me, that's not going to be enough. So where are those other cars going to go? And how are they going to get out? How frequently are they going to be going out? And I think that just puts a burden. They're going to end up parking in the bowling alley parking lot. They're going to end up parking on Willetta, which is a very narrow street. And they're going to end up walking back into the neighborhood to park. And that might seem pretty far for some people, but I've seen other neighborhoods where that's happened. There was a similar thing up in West Salem where they parked really far away in order to get home during the day. And I think that many cars, I just don't think their estimates for traffic are correct. I think they need to take a look at again and say, really do the transportation study, because I feel like in looking at the data that their assumptions are incorrect, that there's something missing. And, I think that's probably the biggest concern. There have been times before, there was an attempt to develop a church stake center kind of in the park, and that was several years ago. And that didn't go through because they looked at how many cars and the impact on traffic, and they actually went and developed it somewhere else, simply because they saw the impact and that was not sustainable as designed. So I think that's probably one of the biggest things that we're concerned over. There is only, they could maybe look at changing the traffic signal. Maybe you could have 2 lanes turning left. Maybe there is something the city could do to kind of help with that, to alleviate the bottleneck that can happen, but it doesn't address what would happen in an emergency. And I think that is the biggest thing. If you've ever, people who've lived here, I'm sure you've been to the bowling alley at least once. Whenever there is an emergency, they park the fire truck in that little lane right there between the mini golf and the bowling alley. I don't know where that would go. Otherwise, there isn't a lot of space when you have a busy bowling center. So how would that be mitigated? Because if my kids go there, they hang out during the summer. We have, I'm trying to understand where the traffic would go and how we can, come to an understanding on how they can address that. I think, I just think that there's just something missing. And I think it would be really great if it could be sent back and addressed, and maybe come back with something where they can say, hey, here is the real traffic reports. I just think assuming that an apartment complex that is not close to services, and you're not going to have 100% of the residents driving, I think is just, maybe we're putting our blinders on and just pretending like the problem's going to go away. But I just don't believe that's the case. We have in our home, we live next to renters. Those homes have 3 bedrooms and they each have 4 vehicles. We are seeing this more and more and more, where because of housing prices, you have people who are doubling up. They're trying to get in as many people as fire code will allow, basically. My son's previous place, there were 4 other guys, and they were living in a very small apartment. And they had basically 3 bedrooms and 5 guys, because nobody can afford the rent. And these are all young kids starting out. You know, they're gonna go to an apartment. When if you've seen the prices of housing, you can see that the available apartments in town for a 1-bedroom, 2-bedroom, $1,600. So you're going to have more people fitting into smaller spaces. That's just our belief and what we see. And I just think that that the transportation plan just seems like like I said, it just needs to be evaluated. And I have concerns also with the riparian area of the wetlands. I know that they did say that they were going to handle they were gonna mitigate any spillage or anything like that into the wetlands. And I was not, when I was looking for this study, maybe I wasn't finding the right one, or maybe it was out of date. But I was looking for, how would they determine what soil to bring in? What kind of testing would be involved in that? Just to make sure that we have addressed every concern. The wetlands is something that is near and dear to everyone who lives there. It's one of the reasons that we all bought there. We love it. If we've gone through the whole trail many, many times over the years. We've all seen the native wildlife, the ones that we like, the ones that we're kind of scared of. And, we've also seen disruption from other construction, where we actually had bald eagles walking down 53rd. They got scared away from the nearby construction. I think it was the Ellingson property when that happened. And so many of those bald eagle families have changed their living space. Many of them are living not too far away. I don't know where they're currently residing, but we just want to make sure that all of that's been taken into account, that we understand the exact impact to the wetlands, and that we've done just our very best to question it and make sure that we have dotted every I and crossed every T when it comes to that, just to make sure. I think my final point, I'm trying not to go too slow because I know there's lots of other people waiting. I think the main thing is that when we moved there, we were told that this space was going to be more commercial, that there was going to be more services added. We've heard it again and again, and we've supported anybody who wanted to come in there and bring in, we liked the dealership. It did provide some limited jobs, but we wanted to see more. We wanted to see, nearby gas stations. We wanted to see small grocery stores. 7-Eleven doesn't count. We wanted to see, other small businesses come and fill the space. We are not against any kind of housing. I think shoehorning 108 units into that tiny space is probably not the best fit. There has to be a better way to coexist with that property, and to provide the things that the nearby communities have been asking for. Many of them have been asking for 20 years. We've talked to people who are said, we've been here 20 years and we've been asking for things, but nobody is developing out here. We were looking for an additional jobs, and instead we're getting apartments. And I looked at a lot of the vacancies. There were like 139 apartment rentals available in Albany when I looked at onapartments.com this morning. And, is this going to fill the need that the community has for housing? Is the pricing, is everything going to fill the needs? Maybe, maybe not. But I just ask that the traffic concerns, the safety, because it is important. If anything happens, it is so important to us that be addressed, and that we know if something happens, that we can get out safely. I think that's it. That's the most important thing.
Thank you. So is Bill available online? Is he online? Giselle.
Thank you for your time.
Thank you very much.
Well, thank you so much, Amanda. We appreciate you. Any questions for any of the appellants? Any more questions? Got a question, Remy? for.
I had a question for Mr. Nyquist.
Mr.
If he's-
Nyquist, could you come back to the table, please?
You mentioned alternatives for the access road or the easement, what have you. What are the alternatives that you have explored or would be interested in?
I would be more comfortable discussing those with the applicant
Okay,
and
that's
working
fair.
through things than pinning something down that
Absolutely.
I'm back in
Good.
trouble
I
with
understand the
conflict in that
effect on the
regard.
bargaining
So,
position that would make. Yeah.
thank you.
Thank you. All right, I'm going to request that we take a 10-minute break. Is that okay? Because I really need to go to the restroom. And we've been sitting here for a couple hours, so can we take a 10-minute break, be back by 7:20? Thank you. It is now 7:20. We'll call the meeting back to order. And now we will be taking public testimony for those who registered to speak. First from those in favor of the application, followed by those in opposition or with concerns, and finally anyone who is neutral. If anyone wishes to enter an exhibit into the record. As part of your testimony, please briefly describe the exhibit and then hand it to the clerk. Virtual attendees, please email any exhibits you have to cdaa@albany.oregon.gov. So we have no one for, have 5 people again. So we will start with Eddie Merrifield, and he's online, or you're here. Oh, okay. You signed up in a virtual location. Please give your name. Yeah, please put your name and address, and we're limited to testimony to 3 minutes, and if you heard something already, just.
All right, I'll talk pretty fast.
Okay.
And I think I can cut some of my stuff. So first of all, Eddie Merrifield, 4703 Falcon Street Southwest here in Albany. I've been here pretty much my whole life. Start out by thanking Roger Nyquist for the nice little rundown memory lane. My entire life, my entire childhood, our families were business competitors. His family owned Lakeshore, my family owned Albany Lanes and Albany Bowling Center. So that was a nice little, I had some memories. Ms. Fee covered most of the things. I had stats and things, and I share a lot of the same concerns. Everybody coming through the end of 53rd, out of the apartment, trying to get out, and people coming in, sorry, should have had some water. People coming in off of Pacific and trying to turn left. And I think that if you do approve this, I think we should have an additional left turn lane built in there. I think she was spot on with that the traffic's just not gonna be conducive right there. But one of the things that was interesting was earlier in the meetings when we were talking about this village center. I was here for all of those because actually I didn't want Roger to build his bowling alley down the street. The interesting thing about that was nobody was talking tonight about Walletta. And at the time that village center concept was going on, the main street was going to be exiting out of Walletta onto 53rd, which is why I didn't want it, why most of the people in the neighborhood didn't want it. We didn't want people coming out of a bar at 10 o'clock at night, turning onto Walletta to get onto 53rd to get onto Pacific. So then that got changed. I don't remember ever hearing anything about a main street that was supposed to go through the Lakeshore property. I just don't even remember it ever being discussed in these public meetings. The other part of the Village Center discussion earlier that I found interesting, and I remember this really clearly, Mayor Canopa putting her arm around me and told me to picture a steakhouse looking over the wetlands and over the sunset and how perfect that was gonna be. The village center that they imagined or that they told us about at that time was restaurants, small shops, maybe some small groceries or something that would service the people that were out there. There was never any discussion of a village center included high-density apartments right there on 53rd. I take a little bit of exception to the process, and I think this is just for the city specifically, only notifying people 1,000 feet of the location when literally every single person who owns or lives in that neighborhood has to be throttled through that intersection. That was a little bit short-sighted on the city's part, and I think the city, excuse me, should maybe adjust their processes. And lastly, Mr. Green, you made the best point. Honestly, of everything that's been talked about, we can't decide what somebody who buys the car lot does with their property. But the intent of the Village Center was exactly what you were talking about, to bring services, to bring restaurants, to bring shops, to bring some level of shopping closer to the people in that neighborhood. Jeff? Oh, okay. Anyways, thank you. I appreciate what you guys do. So.
All right, thank you. Next is Bill Olliant. I'm sorry if I'm pronouncing your name wrong.
I'm Bill Allison.
Allison, okay.
Hello, everyone. I'll be very short because most of what I have to talk about has already been said.
Great. Make sure you put your name and your address for the record.
Okay. Oh, address, 1975 Kodiak Avenue Southwest. I'm in the Animal Kingdom there off 53rd. Albany needs housing, definitely, but it's got to be without negative impacts to the people who are already living there and the businesses that are there. The project's going to add a lot of cars right there at the intersection between 53rd and 99. And as a number of people have already said, that's a choke point now. It's going to be even worse one. With the road, with 53rd the way it is now, there's no room to queue up to turn left. And especially with people trying to turn into the apartment complex, there's going to be no room for those to queue up. There's going to be log jams and accidents. So a couple of people have mentioned putting in an additional left turn lane, make some additional queuing space for the people turning into the apartments, for the people heading north out of 53rd. Because the bulk of people going to that intersection are going to be turning left to go to Albany, not going to Tangent. The other topic I have concerns the fill that'll be put in to the riparian area so that they can build the way everything's planned. My concern is that that be put in such a way that erosion doesn't occur and wash a bunch of silt down into the wildlife area. And I'm sure that can be done. But is there any thought given to controlling human population wandering from the apartments down into that area? I picture a lot of paths going down there, which are then going to be sluices for erosion and more mud getting down into that area. I hope that that's being taken care of and you know, some solution is identified for that. And that's it. Thanks very much.
Thank you. All righty. Okay, Eddie's already up there. Elaine? Albert, do you want to speak again? Okay. And Shannon Steffen?
Thank you. Hi, I'll make this very brief. Shannon Stephen, 1950 Cougar Avenue, Southwest, affectionately the Animal Kingdom, as all the residents and realtors call it. Very briefly, I just wanted to say that my husband and I and our two babies moved into our neighborhood in 2004. We've loved it, never wanted to be anywhere else. A lot of great aspects, one of which is sort of a suburban feel without living with constant traffic. My main concern is traffic on 53rd. And I completely understand and didn't realize how much of it would be filtered through Rogers Bowling Alley. And I can say for sure that is not safe. My kids and I and my husband have spent many, many hours at the bowling alley, and for traffic to be going through there, that's scary. If it isn't, though, that means even more on 53rd. I came to meetings back when the LDS Stake Center was applying to be where our Doug Killen Park is now. Thankfully, that was overturned and they were not allowed to build it there. Nobody ever had any opposition to a neighborhood church, but they had decided that it would be probably a 20-minute wait for residents at that light on Sundays to get out onto 53rd. Excuse me, not onto 53rd, onto the highway. And I think they thought that was acceptable, and I think you would agree if you lived in the neighborhood, 20 minutes to turn onto the highway was not okay, especially since we only have one way in and out of that neighborhood. If there was an emergency, and we've got over 600 homes, lots of people aren't going to be able to get out. And if you add another 108 residences with this apartment complex, that to me increases the hazard and the safety issue too much to be acceptable. I really believe there's a need for apartments, maybe not, you know, lots more, but enough to understand why the desire to build is there. I just don't think this is the best location. We have already got traffic going in and out, which is acceptable, but you add 108 more residences, and I feel like it's a real safety issue. Plus, it's a livability issue for those of us, our quality of life. We chose the neighborhood because it's a little bit off the beaten path and it's nice and quiet. we didn't choose to live there to have even more traffic where we can't come and go as we need to. So I feel like it's a safety issue. It's also a livability issue. I was very pleased that they turned down the application for the Stake Center.
We're at 3 minutes.
All set, because that was just too much, and they decided that was too long of a wait. Thank you so much.
Thank you. All righty. Okay, we will now be taking public testimonies for those who did not register to speak. If you would like to speak, please raise your hand if you are attending in person. If attending virtually, please turn on your camera and raise your hand to be called upon. Or if you are attending by phone, please unmute yourself and state your name so you can be called up. So if you, excuse me, please state your name and address for the record and provide your information on the sign-in sheet to the presenter's desk. If online, please email it. Does the app, anyone wants to speak that's not registered? Anybody online? Is there anyone online? Does anybody online wish to speak? Nobody's unmuting? All righty. So does the applicant have any rebuttal testimony?
Thank you, Chair Miller and Planning Commissioners. Again, for the record, my name is Mike Reeder. At this time, I wish to address a couple of the issues that were raised by public testimony. The first one is that we have provided the city a traffic study. That traffic study looks at first of all, this traffic study is scoped by the city, by city staff, your hired experts, and the traffic engineer, Chris Clemo, who is a very reputable traffic engineer who practices throughout the state, has provided, it's in the record, the traffic study. And the technical memo from Mr. Nyquist does support the conclusion of Mr. Clemo that the intersection at 53rd and Highway 99 East meets the mobility standards, and also Mr. Clemo's conclusions based on the data that he has shows that this project will be safe. Now, in my over 20 years of practice dealing with land use issues, traffic is always the issue that is raised by neighbors. The difficulty that my client has in responding to those is it sounds insensitive to dismiss people's concerns about safety. That's one of our highest and most basic functions of government, is to provide for health and safety and public welfare. One of the other one of the basic functions of government is to provide for the means of people to have laws that they can abide by and rules that are fixed so that they can use and develop their property. My client has provided all the evidence in the record necessary for you to affirm the planning director's decision that they meet the criteria for approval for housing. So some of the testimony that you heard tonight was regarding housing and the critical need for housing. Well, there's no secret that we need more housing in this state and in this community. And my client is an organization that provides housing. So we have 108 units. So we could have potentially over 200 people living in this area that currently don't have that option. And providing those options is a health and safety and general welfare and livability issue. This property was planned for and zoned for residential. And that's what's being proposed. Furthermore, the state, as I provided to you in my earlier testimony, has given us a statute that protects applicants for needed housing in this situation. In this situation, my client has the right to rely on clear and objective standards for developing the property for residential. He didn't make the rules. The property is subject to the rules of the game. And so sometimes those rules can appear conflicting, and they can be not clear and objective. And when the city adopts non-clear and objective standards as they relate to housing, those clear and objective standards must be waived. So my client is not enthusiastic about a remand because we believe that the planning director got it right. Even if the planning commission modifies the planning director's approval such that there's no access through the Nyquist property, the criteria of approval have still been met. There is not a need to go back through another process to amend the application. The application shows adequate access onto 53rd Avenue. So I'm asking this planning commission to affirm the planning director's decision, adopt findings that show conformance with all the criteria of approval, whether there is access through Mr. Nyquist's property or not. You can determine whether or not there's a condition of approval that there has to be access through there, but I don't believe that it's required. And based on the testimony tonight, I wouldn't recommend it. My client meets the criteria of approval for access off of 53rd. My client didn't create this condition that we're in, but the property cannot be held hostage to conflicting and non-clear and objective standards. The city council adopted the rules of the game, and the planning commission is entrusted with applying those rules of the game in this particular case. In any case, if there's a procedure or a condition or a criterion that would discourage needed housing through unreasonable cost and delay, those provisions must be waived. If those provisions are not clear and objective, and we've heard tonight that they're not clear, we can't even agree on whether or not there's passage through Mr. Nyquist's property. That is not clear and objective, and it cannot be required. So, in conclusion, I would strongly urge this planning commission to approve this application, to adopt findings consistent with our testimony tonight. I'm happy to help draft those findings that would pass muster. And if you have any questions, I'd be happy to answer any of those questions tonight.
I have a question. If I missed this and all the applications going back and forth, I apologize. In between, on 53rd, there's a divider line with some trees and stuff. Would your applicant be paying for the cost to remove that to provide a left-hand turn lane? I mean, otherwise you couldn't turn left from coming down 53rd.
Whatever is in the proposal is what my client is willing to do. I don't have a precise answer for you because I'm not as familiar with the site plan as planning staff.
Staff now, is that part? I mean, you couldn't turn left without doing it.
So the site plan that was submitted, based on the TIA that was also submitted, provided mitigating measures for left turn pocket on 53rd.
Okay.
I have one. Sure. Relative to what you meant about providing the local government being under an obligation to provide housing, do you know the average cost of the average predicted cost of the homes in your client's proposed property relative to the average median income in this area?
I do not.
Okay.
And I would respond that the state statute for needed housing requires that there be clear and objective standards for needed housing for all income ranges. So low income, moderate income, higher income. So it's the fact that I don't know is really irrelevant to the criterion for approval. I also will say the law of supply and demand would kick in because the more housing units you have, the more competition there is for the potential tenants.
Thank you.
Question? Madam Chair?
Oh, yes.
Question? Mr. Reader, would your client be willing to develop the South Pacific property into a real village center?
I am not familiar with the South Pacific property. We have not discussed that, so I don't have an answer for you.
Would you check that out with him? This, in other words, the South Pacific property just north of where we're talking about, north of 53rd, running up to 49th, actually, between Highway 99.
I think I know
and-
what property
and-
you're talking
And
about.
Willetta.
You're right.
And that would, of course, include an improvement of Willetta and so forth. With shops that people use and want and would like to have nearby where they live. All people, both apartment dwellers and homeowners.
Yeah. Again, I've been on this project for about 2 weeks, so we have not had that conversation. I will have that conversation with my client.
Good, yeah, thank you. All right.
Okay, there's no more question. Does the applicant waive the 7-day period to submit additional written arguments?
I would suggest that your legal counsel walk you through that because Ms. Albrecht has asked that the record remain open, and she has a statutory right to that. You my guess?
Madam Chair, may I offer some rebuttal prior to close?
Well, I do object to the rebuttal.
Well,
unless you unless it's in
opportunity
your code.
opportunity to deal with procedural considerations with both my requests to leave the record open. So we would respectfully request that the Planning Commission move tonight to continue this hearing to a date certain and leave the record open for anyone to submit additional evidence or argument to the Planning Commission to inform the Planning Commission of its decision at the next set date for the hearing. This gives the appellant an opportunity to respond to applicants' materials that were submitted tonight that we hadn't seen yet. It also gives us an opportunity to respond to questions that we heard tonight about potential interests of the Planning Commission's direction, and it allows the applicant and the appellants and then the community an opportunity to have further discussions that we hope will lead towards a good path forward. So with that, I would respectfully request that we continue to a date certain. Thank you.
So, Joanne, behind your chair guide, there is guidance on continuances, including possible options for keeping the record open for your consideration.
Chair Miller, if I might ask staff, where are we on the 120-day rule?
The 120th day is March 23rd, 2026.
Okay, so we have had a request for a continuance. A continuance may be requested by any person or the hearing body. So we can grant that request. We have talked about it in case there was a request, and we would continue the hearing to be held on March 30th. Is that correct, David, at 6 o'clock?
That is a good date for that, yes.
Would we do 5:15 or 6?
5:15 would be your normal time to meet.
Yes.
Chair Miller, or maybe, I don't know, maybe this is a question for Ms. Harris. 120 days, we're already past the 120 days at that point, right?
We would be. So an applicant can grant a extension to that 120 days.
Okay.
If the applicant also cannot request it, we would just continue through. It just gives them the opportunity to submit a writ to the courts.
Okay.
The next step, David, help me here.
Drive to the 31st. Date certain.
I have a question, actually. Well, okay, so from my understanding, the commission can, in response to the request for continuance, the commission shall either grant two options, leaving the record open or continuance. If the record is open, it has to be held open for at least 7 days. But if it's continued, it must be to a date certain. Am I missing anything on that?
That's correct. We're requesting to a date certain to leave it open and then continue the hearing at that date certain, hoping that the applicant will consider an extension of the clock until the 31st,
The 30th, March 30th.
at the close of the hearing or something. Hopefully that can be a consideration.
Any
Or
other
the
points?
applicant's representative, Mr. Reed.
Yeah, so, Madam Chair, my client is ready to move forward with the application as presented. So the statutory requirement that you hold the record open for 7 days is a requirement. You, as a body, have the opportunity to have a continued hearing at a date and time certain. So if you were to decline the invitation by the appellant and to move forward with the 7 days of open record period, then all parties would have the opportunity to present evidence, new evidence, argument within that 7 days or longer should you so choose. And then there would be 7 days for response to that new evidence, and then 7 days for the applicant to provide final written argument. And that's what the applicant recommends the Planning Commission do in this case.
So we're choosing to go with the continuation?
I'd move to grant the continuance.
I'm sorry, I didn't hear you.
Yeah, I move to grant the
To
continuance.
March 30th.
To
I think
March
the
30th.
applicant,
Have like 3 minutes
yeah.
of discussion, just to try to recommend a good path forward on this.
Okay, I withdraw the motion.
Okay, thank you.
Really?
Everybody's whispering, but continuance or move it to another date or whatever, leave the record open. I only got 3 minutes to talk. Does that mean if I submit my full email, my input, that it's still open to be considered? I kind of went as fast as I could.
If the record is left open, anybody can submit testimony. So anyone can submit a new argument.
Okay. Attorney, can you outline what the option is by leaving the record open, what that would look like?
So the record would be left open for 7 days. I believe it's a little different than a continuance.
The Planning Commission has the discretion to set the clock. It must be a minimum of 7 days.
That's what I said, at least 7 days.
The Planning Commission could leave the record open through the date of the hearing to take new evidence. The Planning Commission needs to consider whether it wants to accept additional testimony at a continued hearing.
So is there a motion for the
I
continuation?
move to grant the continuance and to leave the record open until the date, I believe it's the 30th?
March 30th.
Yes, March 30th.
March 30th works for the applicant.
So we will, yeah. Is there a
I second.
Skylar, you second? Okay. Any further discussion
Just one
about
thing.
about the continuation? That's it.
I just want to make sure the motion is to grant a continuance to March 30th at 5:15.
Yes.
Just, I think we forgot the
Yes,
time.
I'm sorry, I forgot the time. Yes, 5:15.
Thank you.
All those in favor?
Aye.
Aye.
Opposed? Okay, so we will have leave the record open and continue on March 30th at 5:15.
Thank you, Chair.
Thank you. Thank you.
Okay. There's nothing else coming before the commission. Our next official meeting is April 13th, so put that on your calendar as well. And if there's nothing else, I'll call the meeting adjourned. April 13th. No.
Hey, Chair, you mentioned that the next meeting's March 30th, right? Oh, okay. And then the April, okay. I just heard the April 13th.